Good day, Crime Talk aficionados. Welcome to another gripping episode of Crime Talk with Scott Reich. I'm your host, Scott Reich, and we're diving headfirst into the latest legal battles and courtroom dramas that have the nation buzzing. Buckle up, because today's show is packed with jaw-dropping updates and intriguing insights. First, we'll start with the latest on the Bryan Kohberger matter. There was a hearing in Pennsylvania today regarding witnesses that, well, let's just say it didn't go quite smoothly. We'll break down the witnesses called and the objections raised and how the court is responding to this high-stakes proceedings. Then we'll shift gears to the federal trial of Sean Combs, where jury deliberations are now underway. Stay tuned. Next, we'll unpack the stunning development in the Kouri Ritchis case, as she now faces 26 new felony charges and what these accusations could mean to her upcoming murder trial. And you don't want to miss our segment on Catch Me If You Can, NOLA edition, where 9 of the 10 jailbreak masterminds have been nabbed in a dramatic turn of events. Plus, we'll take a moment to reflect on this day in legal history, share a thought-provoking legal quote of the day on constitutional interpretation, and wrap up with a wild story from Florida, where a man's surgery revealed far more than just a knife wound. So grab your coffee, settle in, and let's get to the truth behind the headlines on Crime Talk. Let's talk about it.
All right, lawyer.
Good day, everyone. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below. And remember, you can check us out on any of your favorite podcasting apps. Now, let's remind you also, go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do as many background searches as you desire. And the report is prepared while you wait, and it is then emailed to you. And so you're going to get the results and find out immediately what people's phone numbers may be, their social media presence, their email addresses. Do they have a criminal history? Are they married? Are they divorced? Do they have legal proceedings pending against them, both civil and criminal? And, do they have to put themselves on one of those lists you hear so much about? So go to crimetalksearch.com. You're going to be happy that you did. All right, one more thing before we get started. You may notice something over here in the corner. Yes, check this out. Received this from a fan. Appreciate it. He gave me permission. Dave Alexander, he owns Retro Rust. He sent me the Constitution Matter signs. Like I said, he gave me permission. So thank you, Dave. Appreciate that as well. And as you can see, it's prominently placed right there on the set. So thank you very much. All right, let's go ahead and open the record for Monday, June 30th, 2025. And first on the docket, that's right, court proceedings were held today in regards to the case of Bryan Kohberger, but guess what? They were in Monroe County, Pennsylvania. And what were they there to determine? Whether 5 individuals from Pennsylvania connected to Bryan Kohberger, obviously the suspect in the Idaho murder cases, would be compelled to testify at the trial scheduled for August of this year. Now, obviously, most people know, but if you don't know, Bryan Kohberger is a 30-year-old criminology PhD student. I guess you could say he's disenrolled. Anyway, he's accused of the November 13th, 2022 murder of 4 University of Idaho students, Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin. Now, the hearing aimed to assess whether these individuals were material witnesses and whether testifying would cause them undue hardship. Now, the proceeding was marked by confusion as several witnesses expressed complete uncertainty about their relevance to the case, and one questioned whether the defense had summoned even the correct person. So let's talk about the witnesses called, their objections, and the court's responses. The first guy was Ralph Vecchio III. Why is he being called? Well, Vecchio owns a car business where the Kohberger family purchased the Hyundai Elantra back in 2019, a vehicle obviously central to the case due to the surveillance footage showing a similar car near the crime scene. Now, the defense likely called Vecchio to provide context about the vehicle purchase of Kohberger's background. Well, what was the objection? Well, Mr. Vecchio strongly opposed the subpoena, arguing he's never met or interacted with Kohberger and questioned whether the defense had mistaken him for his 88-year-old father, also named Ralph Vecchio, who owned the business back in 2019. He stated, quote, "I've never seen in my lifetime or talked to him in my lifetime the accused, end quote, and noted that Kohberger's parents, not Kohberger, purchased the vehicle. Vecchio also cited hardship as traveling to Idaho would disrupt his business operations, and he is somewhat reluctant to fly, not to mention his father is basically homebound. Anyway, defense attorneys admitted uncertainty about whether Vecchio was the correct witness. The judge, Arthur Zolnick, ordered the defense to clarify by July 7th, 2025, when Mr. Vecchio was ordered to reappear. Now, the judge noted the possibility that the wrong person was subpoenaed, as the elder Vecchio is housebound and unable to testify. Like I said, Mr. Vecchio's testimony, if required, would likely focus on the car purchase transaction, though he claims no direct interaction with Mr. Kohberger, limiting what he believes his relevance to specific details about the vehicle's acquisition. More than likely, he could lay the foundation for the documents, but it's interesting that the defense is calling this particular individual. Maybe they're going to say, well, the car was sold to Mr. Kohberger's father, therefore, obviously, he must be the real killer. Hey, that's the way some of these people think these days. Next witness called was Jesse Harris. Harris works at a boxing gym where Kohberger trained as a teenager. The defense likely called him to provide character evidence from Kohberger's youth, potentially to mitigate the death penalty phase if it gets there, as trying to show him as a non-violent person. What was the objection from Mr. Harris? Well, Mr. Harris opposed the subpoena, arguing his knowledge was limited to Kohberger as a 15 or 16-year-old and not the 29-year-old accused. He stated, quote, "I don't know how my relationship with a young man is pertinent to this case," end quote. And Harris feared his testimony might misrepresent boxing as violent, clarifying Kohberger never fought competitively, but trained for confidence and fitness. He also cited hardship due to his wife's illness and his role as the family's sole provider, and concerns that testifying would imply support for Kohberger, which he denied. The judge approved the subpoena, ordering Mr. Harris to testify, but agreed to reassess if Mr. Harris's wife's medical condition worsened. So Harris is expected to describe Kohberger's teenage character, emphasizing his non-violent participation in the gym to counter the prosecution's narrative of a violent individual. His testimony may highlight Kohberger's struggle with self-esteem as he trained to build confidence rather than to compete. Then we had Brandon Andriola. Andriola attended high school with Mr. Kohberger, though their relationship was described as minimal and distant since graduation. The defense likely sought testimony to provide insight into Kohberger's high school behavior or social interactions, possibly to establish a pattern of non-violent conduct. Now, Andriola strongly contested the subpoena, noting his last significant interaction with Kohberger was back in June of 2020, 2 years before the murder. He feared job loss due to media attention, citing the example of Kohberger's sister, who lost her job after his arrest. And Andriola argued that the media scrutiny from testifying could jeopardize his livelihood. Well, despite sympathizing with the concerns, the judge ordered Mr. Andriola to comply with the subpoena and to testify in Idaho. Now, Andriola's testimony is expected to cover his limited interaction with Kohberger during high school, potentially addressing Kohberger's demeanor or social standing. And the defense may use this to argue Kohberger lacked a violent disposition in his earlier years, though the relevance is unclear given the distance connection. Then we had Mr. William Searfoss. Now, Mr. Searfoss is a prison officer at the Monroe County Correctional Facility, where Kohberger was held for 5 days following the December 30th, 2022 arrest of Mr. Kohberger. The defense is likely calling him to provide information about Kohberger's behavior or condition during detention, possibly to support arguments about his mental state or treatment. Now, Mr. Searfoss did not explicitly oppose testifying at the trial, but believed his role was fulfilled by providing prison records to the defense. He suggested this would negate his need to appear in Idaho. The judge instructed the defense to review the records by July 7th to determine if Mr. Searfoss's testimony will still be necessary. A final ruling on his subpoena was deferred. Now, it is anticipated that if he were required to testify, he would testify about the conduct during the brief detention with Mr. Kohberger, such as his demeanor, interaction with staff, or any notable incidents to provide context to his post-arrest behavior. Then we had Anthony Soma. Mr. Soma's connection to Kohberger is unclear, but may relate to their attendance at the Monroe Career and Technical Institute, where Kohberger was in a youth law enforcement program. The defense likely called him to discuss Kohberger's participation in the program or his character during that time period. Now, Soma did not object, and he reached an agreement with the defense to testify moments before the hearing, canceling the need for his appearance in court that day. Now, the court accepted Soma's agreement to testify, requiring no further action at that particular hearing. And like I said, it's more than likely his testimony would involve the law enforcement program that both he and Kohberger were in prior to his removal following complaints from female students. This could be used to explore Kohberger's early interest in criminology or behavioral issues. So the defense strategy appears focused on Kohberger's upcoming trial and focusing on his upbringing and character before the murder to humanize him and potentially avoid the death penalty. Now, Ralph Vecchio's testimony, if clarified as relevant, would center on the Hyundai Elantra purchase, though his lack of direct contact with Kohberger limits its impact. Jesse Harris and Brandon Ariel expected to provide character evidence from Kohberger's teenage years, emphasizing some nonviolent traits. Not exactly relevant when you're charged with a murder today, right? Anyway, it's for mitigation purposes as it relates to the death penalty, if that ultimately becomes an issue. And then Mr. Soma would discuss his experience at the Technical Institute, potentially highlighting his behavioral issues and his interest in criminology. Now, the confusion over witness selection, particularly Vecchio's case, suggests the defense is casting a wide net to gather background information, though some witnesses' relevance obviously is remaining unclear. So I understand what the defense is doing, and they're doing their job. I'm not going to fault them for doing that. It is better to have a witness under subpoena and sitting out there in the hallway and not need them than it is to need them and not have them. That's why you get a little crazy sometimes with subpoenas. And yes, it is inconvenience. And yes, you have to pay for their time and their travel expenses and their per diem and all those types of things that come with making somebody go to court when they don't want to. And the goal is to try to minimize the inconvenience as much as possible. But I've also learned over the years that you want jump up and down witnesses, people that are going to really help you. And I'd rather have one jump up and down witness than four lukewarm, well, yeah, I knew the guy, but I haven't talked to him, since like 5 years ago and don't really know what's going on with his life. But at that time he was, okay, right? I'd rather have somebody say, God, this guy was so great. He helped me in life, something along those lines. But I get the defense wants to have these witnesses available to them. It's easier to call them off than try to get them there mid-trial. And it's nearly impossible if they haven't been ordered by subpoena during this interstate agreement to basically have them ordered by the court there to do that. Otherwise, like I said, I've said in past shows, the subpoena in Idaho is worth the paper that it is written on in Pennsylvania. That's it. It's a request at that point. We're pretty pleased. Will you come to court? But now they're ordered to come to court and cooperate with the defense in getting on that plane to go to Idaho. We'll see where things are headed, ladies and gentlemen. Obviously, the defense seems to be very focused on mitigation. Trials coming up. Their motion for a continuance was denied. Their motion for third-party perpetrator evidence was denied. We talked about that last week on Friday's show. You should go check it out if you want to know the court's rationale for doing it, because we went through the entire opinion. And it was rather clear that the defense did not impress Judge Hippler with their attempts to throw the responsibility for these homicides onto four people that clearly had no involvement whatsoever. And the judge let the defense know their evidence was lacking. Let's just say it that way. He blasted them pretty hard. Judge Hippler is a no-nonsense guy. I have dealt with Judge Hipplers over the years, not Judge Hippler personally, but judges like him. They're no-nonsense, to the point. You show up, you make strong legal arguments, you don't waste his time with BS arguments, and he's going to give you a fair trial. But if you lose, guess what? Your client is going to get whacked. Now, obviously, that's not really the case here. The judge doesn't do that. But this judge, he knows the law. And I won't even go into some of the things that I've seen on various posts that I was looking at over the weekend. Some people just, you can't ignore the law, okay? And judges' job is to follow the law, whether they like it or not, whether they agree with it or not, just like the attorneys have to follow the law, whether they like it or don't. But I guess if you don't practice law and you don't have to go to court and present this argument, you don't have to follow the law. You can make up your own facts if you want to. And Judge Hippler's not allowing the defense to do that. And if there was a legal basis for it, he would allow the defense have their cake and eat it too. Hey, I want the defense to hold the government to their burden of proof. We'll see what the evidence comes out. As we've learned, you never know what a jury will do. I have won trials that I should have lost because I had a jury that you just think, wow, we just found 12 of the dumbest people in the metro area. I wonder if there's a 13th, right? Literally just leave you scratching your head. But for whatever reason, and it depends on who's on that jury, they'll do what they want, whether it's jury nullification. I mean, I've had cases where literally the court reporter's like, oh, this is going to be a not guilty. I had the prosecutors telling me, oh yeah, we lost this. And they came back on second degree murder once. And guy got 96 years. Then it got reversed on appeal because apparently I was right at some point, right? But apparently I wasn't correct in picking that particular jury. Everybody thought we won. I mean, there was like a Matlock moment. Jury was like, yeah, we don't like your guy that has tattoos on the head and mean mugs the jury and mean mugs all the witnesses in the case. So juries are an unknown part of any trial. And like I said, it's the worst, second worst part of a trial is when the jury goes and deliberates. The worst part is when they say, we have a verdict. And like I said, after doing this for many, many years, it still makes my stomach sink. We did a trial back in March, a trial that we on paper should have lost. And prosecution wasn't able to get certain things into evidence. And when prosecution looks incompetent because they can't get stuff in, it doesn't instill trust and confidence in their case by the jury as well. And they found my guy not guilty. And I literally, when I heard the verdict, I looked at my client and I said, did she say not guilty? And he looked back at me, he goes, he did. So you never know, ladies and gentlemen. You never, ever know. All right, let's move on. How about the jury deliberations are underway in the Sean Combs federal trial? That's right. So after approximately 70 minutes of deliberations, the jury in Sean Combs federal trial sent a note to the court. The contents of the note remain undisclosed. Attorneys for both sides, the prosecution and the defense, along with Mr. Combs, had returned to the courtroom, and the judge had not re-entered yet. We do know that the jury elected juror number 5, a 42-year-old mother of 2 and a nursing home aide from Manhattan, as their foreperson. Now, during jury selection, she described herself as a person of color who prefers receiving news by word of mouth. She disclosed a minor infraction some 15 years ago for carrying an open container and noted general familiarity with the allegations against Mr. Combs. Deliberations commenced in the trial when Combs faces charges of racketeering, conspiracy, 2 counts of sex trafficking, and 2 counts of transportation for prostitution, all of which he denies. Now, the judge instructed the jury to base their verdict solely on the evidence presented or the lack thereof. The jury, consisting of 8 men and 4 women, were provided with the transcripts, a laptop containing evidence, a list of exhibits, the jury instructions, and a verdict sheet. Their first task was to select a foreperson, obviously, which we know that they now did. Well, the alternate jurors remain on standby and must adhere to all instructions until a verdict is reached, which means they can't talk to anybody about the case. Because if a juror had to be excused, the new alternate would come in and they would have to start their deliberations anew, since that person hadn't participated in the deliberations up to that point. Anyway, the jury is going to deliberate until 5 p.m. or unless they all agree, and they're going to have their meals provided. Now, before the jury actually began their deliberation, the judge read the instructions, which took a little over 2 hours, and it outlines all the instructions outline the legal standards for the 5 criminal counts, and he emphasizes the jury role in determining witness credibility and the truthfulness of facts, noting that they may disregard a witness's testimony entirely if found to be willfully false. The judge detailed the elements requiring to convict Mr. Combs, who embraced his legal team before the proceedings began. And as you may recall, the jury selected starting May 5th has spent 35 days in court, including 1 replacement juror with an alternate. We'll wait and see. Indictments never read well, okay? The bottom line is they sound bad. They're very one-sided. But it's an allegation, and then the prosecution has to prove beyond a reasonable doubt to each and every element of those legal elements beyond a reasonable doubt. If they fail to do so, it's the jury's oath and obligation to say not guilty. Now, on the flip side, if the jury is convinced that the prosecution has proven their case, it's their solemn oath and obligation to say guilty as well. But as things progressed in the Combs trial, it became clear that the allegations were not exactly what the prosecution presented in the indictment. The prosecution dismissed several counts that they believed were probably going to get dismissed for on a motion for judgment of acquittal. Not a good sign, right? And the jury's going to remember that. They heard the allegations up front, and they're going to say, why are all those other charges? That's interesting. And so things did not turn out. Now, clearly, Mr. Combs was involved in some interesting behaviors with people, but hey, as long as they're consenting adults, that's it. And everybody appeared to be consenting adults at the time. It wasn't until afterwards when they suddenly felt like, since I'm no longer getting money, that I'm pressured to do so. But guess what? That's for the jury to decide, but we'll have to wait and see. But I think, I don't know. I don't want to be 0 for 2 in July here. I don't want to be 0 for 2 in June here. But, the big stuff, I think Diddy's got a shot. He's got a shot. Anyway, the trial obviously addressed those allegations of Combs leading a criminal conspiracy involving the trafficking of women and transportation of prostitution. Obviously, the trial ultimately addresses these allegations that Combs led a criminal conspiracy involving the trafficking of women and transportation of prostitutes. Now, the prosecution urged the jury to find Combs guilty, citing 2 decades of all these alleged crimes. The defense argued the case, is exaggerated, framing Combs' actions as consensual on part of a specific lifestyle. The jury, with their ages ranging between 30 and 74, all holding college or advanced degrees, heard this 6 weeks of testimony involving these allegations, and obviously they will come to their conclusion at some point. Once the news breaks, we'll bring it to you on Sean Combs. I think he's got a chance. At least in some of the big stuff. He may get popped on some minor thing, but thank goodness having too much baby oil is not a crime. Next, let's talk about Kouri Ritchis. Remember her? Well, guess what? She now faces 26 new felony charges. So, Kouri Ritchis, the 34-year-old mother and real estate agent from Park City, Utah, who is accused of orchestrating the death of her husband, Eric Ritchis, back in March of 2022. Well, now she faces an aggravated murder charge for allegedly poisoning the 39-year-old husband, as well as a charge of attempting to murder him a month earlier. Now, the couple's relationship was, reportedly strained by financial disputes, particularly after Eric discovered Kouri had taken out a $250,000 home equity line of credit on his premarital home in 2019 without his knowledge. The loan funded Kouri Ritchis Realty and its operations, which prosecutors allege were mired in unsustainable debt. Then by late 2021, Kouri Ritchis Realty was in severe financial distress, owing at least $1.8 million to hard money lenders at the time of Eric's death. And the day after his death, the debt reportedly ballooned to nearly $5 million. Prosecutors claim that Kouri believed she would benefit from Eric's $5 million estate and several life insurance policies, though she was mistaken about being the beneficiary on some of those policies. Now, her trial for murder is scheduled to begin with a jury selection on February 10th of 2026, and the trial itself probably about February 23rd. But on June 27th, just last week, Ms. Ritchis was charged with an additional 26 felony counts in Summit County, and these charges relate to financial crimes. 5 counts of mortgage fraud, 7 counts of money laundering, 1 count of communications fraud, 1 count of engaging in a pattern of unlawful activity, kind of like racketeering, 5 counts of forgery, 7 counts of issuing bad checks. And these charges stem from allegations that Ritchis engaged in fraudulent financial activity tied to her husband's death. And according to the court record, she used a power of attorney to secure this HELOC loan without Eric's consent and misrepresented its repayment status. Additionally, she allegedly falsified mortgage applications, blaming her low credit score on others, including Eric as an unidentified individual in Seattle. Prosecutors further allege that Ritchis' real estate business was on the verge of collapse, with unsustainable high interest loans used to purchase properties, including a $2.9 million unfinished mansion. Now, the charging documents also highlight a pattern of unlawful activity, accusing Ms. Ritchis of falsifying an insurance application on Eric's life and attempting to kill him for financial gain on multiple occasions. Now, these new charges may significantly complicate Ritchis' legal status and may influence the trajectory of her murder case as well. Now, previously, 2 counts of mortgage fraud and 2 counts of forgery were severed from the trial, and the addition of the 26 felony charges suggests prosecutors are intensifying their efforts to portray Ms. Ritchis' alleged financial motive as central in the murder case. So, by linking the financial crimes to Eric's death, the state may aim to strengthen its narrative that Ritchis killed her husband to alleviate her crippling debt and access his estate. However, Ritchis' defense attorneys have criticized the timing of the new charges, arguing that they reflect the prosecution's lack of confidence in securing a murder conviction. And they contend that the financial charges would only become relevant if the murder case fails, as these allegations depend on establishing a motive tied to Eric's death. The defense also expressed concern about the potential impact on jury impartiality, and the new charges could affect the murder trial in several ways. First, obviously, jury perception. The extensive financial charges may paint Ritchis as a calculated individual driven by greed, potentially swaying jurors' views on her character and motives in the murder case. And that's not to mention trial strategy. The prosecution may seek to introduce evidence of financial misconduct to support the murder motives. Sound familiar? Alec Murdaugh, South Carolina. Anyway, while the defense could argue that these charges are a distraction from the murder case. And obviously, legal resources. Facing an additional 26 felonies may strain Ritchis' legal team, potentially diverting resources and attention from the murder defense. And let's not forget that bias, right? This is a high-profile case. Amplified by new charges could complicate efforts in securing an impartial jury. When it rains, it pours for Ms. Ritchis, that's for sure, right? Next thing you know, you're writing children's books and being a real estate guru. Next thing you know, you're sitting in jail charged with murder and then 26 counts of financial fraud. Just never realize how quickly all things can change. Next, Catch Me If You Can, the NOLA edition. 9 of the 10 jailbreak geniuses have been nabbed. Well. New Orleans' Great Escape Saga is nearing its grand finale, and it's been a wild ride. The Orleans Parish Sheriff's Office has finally rounded up 9 of the 10 inmates who thought they were starring in their own prison break blockbuster back on May 16th. The latest? Antonio Massey, who was caught lounging in a Holly Grove rental like he was on a budget vacay. But thanks to a tipster who clearly deserves a gold star and maybe a coffee gift card at least, things didn't quite turn out so well. Anyway, Sheriff Susan Hudson's team got word of Massey's hideout on Friday at about 11 a.m. By 3:30 p.m., guess what? The police were storming the residence with more feds than a spy movie. FBI, Homeland Security, U.S. Marshals, you name it. Massey, to his credit, didn't pull a dramatic standoff. He surrendered like a guy who knows the jig is up and was whisked off to the Louisiana State Penitentiary at Angola. As you may recall, just 6 weeks ago, 10 inmates from the Orleans Parish Justice Center turned a defective cell door into their golden ticket. They busted through it, smashed a wall behind a toilet, real classy, and slipped out via a supply dock door. For the grand finale, they scaled a wall and sprinted across the interstate like they were auditioning for an action flick. The aftermath, though, a manhunt that's been part cat and mouse, part comedy of errors. On breakout day 1, Kendall Myers was found cowering under a car in the hotel parking garage nearby. Smooth move. Anyway, that same day, Robert Moody was nabbed near Central City, and DeKenyon Dennis was plucked off the street near Chef Mentor Highway. And by May 19th, Gary Price was back in cuffs, followed by Corey Boyd, all by May 20th. Then Memorial Day brought Lenton Vandenberg's capture in Baton Rouge, while Leo Tate and Jermaine Donald thought Texas was far enough. Spoiler, it wasn't. Now only one mastermind remains at large, Derek Groves. And if you're hearing this, Derek, maybe consider turning yourself in. The feds aren't exactly slacking. Now, as for Mr. Massey, he has his Zoom court debut from Angola, facing a shiny new charge of aggravated escape. And the Attorney General wasn't mincing words, calling Massey's literally the walking definition of a flight risk, and demanded he stay locked up without a bond. The defense attorney called that absolutely ridiculous, but the judge wasn't buying it. Massey's staying put, and Massey's pushing for an extra 10 years tacked onto the sentence that Mr. Massey was already facing. Ouch. So here we are, 9 down, 1 to go. Will Groves keep dodging the law, or is he next on the handcuff parade? Stay tuned. The sequel's bound to have a killer ending. And next, a Florida physician facing felony charges for allegedly extracting fentanyl from patients' IVs. Yes, you heard that correctly. So on June 23rd, the state of Florida formally charged Dr. Sasha Boris Grech, a 52-year-old anesthesiologist and critical care physician, with felony possession of a controlled substance following an incident at an HCA Florida Lawnwood Hospital in Fort Pierce. Prosecutors allege that back in December 2024, Dr. Grech extracted liquid fentanyl from a patient's intravenous IV using a syringe while working a night shift in the intensive care unit. Now, according to the St. Lucie County Sheriff's Office, hospital staff observed Dr. Grech exhibiting unusual behavior. Surveillance footage and a nurse's cell phone recording reportedly captured him withdrawing fentanyl from a patient's infusion pump. Now, HCA was very diligent and reported the issue to law enforcement immediately, and an internal hospital review identified discrepancies in medication dosages, prompting a law enforcement investigation that led to the single felony charge. Now, the case filed by the state attorney in this particular case is supported by a sworn witness statement and video evidence. And Dr. Grech has a prior criminal history, including a 2006 arrest in Alcoa County for 129 counts of obtaining a controlled substance by fraud and 1 count of cocaine trafficking. He pled no contest to 4 counts of fraud, receiving 5 years of probation. Now, anyone who knows anything about hospitals knows that sometimes this is not an uncommon circumstance in the healthcare industry. Now, normally, fentanyl is typically secured, but preventing this behavior is somewhat challenging without constant monitoring for signs of impairment among medical staff. The HCA Florida Lawnwood Hospital issued a statement, of course, emphasizing its safeguards for medication administration and its swift response in reporting the suspected diversion to authorities. The hospital confirmed that Dr. Grech is no longer practicing at that facility, and they reaffirmed their commitment to the high standards of care. Now, if convicted, Dr. Grech faces up to 5 years in prison and a $5,000 fine. The case continues to unfold as they're further investigating. Now, listen, I hate to say it, and my daughter, She's an NP. And I hope she never, gets in any kind of situation. I hope nobody gets in any kind of situation. But I've represented a lot of nurses over the years, ladies and gentlemen. And obviously you get a criminal case when you get a nurse, but then you get the nursing board. And I'm telling you, the nursing board is one of the toughest, strictest places that you will ever go. Even deferred judgments, they treat as convictions. They're very, very tough on nurses, particularly when it comes to care for, obviously, the patient, but anything to do with drugs or any kind of crime of moral turpitude involving honesty. Look out. Tough. I wish the doctor well. Obviously, if he's got a fentanyl issue, probably don't want him practicing medicine. We'll give him the presumption of innocence, obviously, but hopefully he can get the help he deserves if those allegations are true. He probably won't have a medical license, so he'll have to get himself a new gig. Next, this day in legal history, on June 30th, 1860, Congress broadened the federal death penalty to encompass additional offenses such as piracy. This is all part of an early initiative to formalize federal criminal law. Then on June 30th, 1948, Congress revised the United States Criminal Code, updating federal murder statutes to establish consistent penalties for major crimes. And on this date in 1971, the 26th Amendment reduced the voting age to 18, was ratified, obviously influencing legal discussions of juvenile justice as well as criminal accountability. That's right. People said, hey, if you're old enough to go fight in a war at the age of 18, you should probably be able to vote. It was also when there was a draft going on. There's not really a draft going on right now, so maybe we should raise it back up to 21. You can't drink when you're 21. I get it. I don't know what to do. I don't know what to say, ladies and gentlemen. 18 is a good age. I've been voting since I was 18, and I think I've made good choices. Definitely think if you can go fight for your country, you should be allowed to vote as to who's going to send you off to a foreign land. For sure. And next, on June 30th, 1994, I know the U.S. Figure Skating Association imposed a lifetime ban on Tonya Harding for her involvement in the assault of Nancy Kerrigan, marking a notable case of criminal conspiracy in sports. And on this date in 2006, in Hamden v. Rumsfeld, the United States Supreme Court held that military commissions for Guantanamo Bay detainees contravened the Geneva Convention, reshaping national security law. And on this day, June 30th, 2020, federal and state authorities prosecuted individuals for protesting violence following George Floyd's death, contributing to, obviously, police reform. And our legal quote of the day, a well-known legal quote regarding the originalist interpretation of the Constitution, is from Justice Antonin Scalia, obviously a prominent advocate of originalism. Quote, "The Constitution that I interpret and apply is not living, but dead, or as I prefer to call it, enduring. It means today, not what the current society, much less the court, thinks it ought to mean, but what is meant when it was adopted." End quote. Now, that quote is from a 2008 speech encapsulating the originalist view that constitutional interpretation should be rooted in the document's original meaning at the time of the adoption, rather than the evolving contemporary societal values. Some people don't agree. Some people think, no, it's a living, breathing document. You have to look at it in today's standards. That's not originalism. That's called activism. And remember, ladies and gentlemen, if you don't like the law, you can change it. There's a mechanism to change the Constitution if you want to, but it's hard, it's difficult, and it's meant to be that way. So it doesn't come like most states where you can put a referendum on as to the state constitution and you just add to it. And frankly, it gets ridiculous. But remember, there you go, ladies and gentlemen, the Constitution matters. And finally, our dumb criminal of the day. Where does it take us? Florida. Of course it does. And involves a man's surgery that revealed a little bit more than a knife wound. So in a plot twist that could only unfold in the Sunshine State, Michael O'Neill, a 43-year-old St. Petersburg resident, turned a routine hospital visit into a headline-grabbing caper. Admitted earlier this month to the Bayfront Hospital for a stab wound, allegedly from a drug deal gone sideways. Mr. O'Neill was under the knife when a nurse stumbled upon an unexpected treasure trove, a glass crack pipe, a lighter, and tin foil packed with cocaine, all cleverly stashed in his rectum. That's right. The discovery, noted dryly in an arrest affidavit, as while in surgery, a RN located the contraband, added a felony cocaine possession charge and a misdemeanor for drug paraphernalia to Mr. O'Neill's tab. Fresh from surgery, he traded hospital scrubs for jail stripes last Friday, only to strut out the next day after posting a $5,500 bond. He did plead not guilty, and O'Neill seems somewhat unfazed by the rap sheet that trails him like a bad cologne. Prior convictions include DUI, a smorgasbord of drug charges, and last year, O'Neill played this game before, pleading guilty to drug possession after a jail strip search uncovered fentanyl and crack rocks tucked in his buttocks. Clearly, he is sticking to his hide-and-seek strategy, though the cops and nurses seem to know all the favorite hiding spots now, don't they? I never understood that, ladies and gentlemen. Several cases over the years where various things have been stuck up various parts of the buttocks. For the ladies, sometimes they use their intimate parts, but I just can't imagine. Just cannot imagine. But my personal favorite is when they used to have cocaine and they would tie it on their genitals and it would hang down in their pant legs so the police wouldn't feel it if they were being searched. They would just, wouldn't feel the string. Think about that. Things that people come up with, ladies and gentlemen. I guess necessity is the mother of invention. All right, that's all we have for today. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.